Contrast that with Jonathan's first slide. He gets to be on. He gets to be on the BBC, CNN. Here's yours truly getting down on a construction site. This one was in London, actually not very far away from here, Bow Street. The Bow Street crane collapse that occurred in July 2020. And I'm acting for the ground workers in connection with that significant investigation. A real crisis. This was a crane that came down, killed an old lady, several injuries, considerable property damage, hundreds of residents being moved out of their accommodation for, as it turned out, for months. You can imagine if you're a relatively small contractor, how something like that is likely to impact on you as a business. You know, they don't have the resources that the Boeings and the VWs and the Santanders have with vast resources to manage these situations for them. So in comes yours truly. I've been sort of involved with crisis events for the best part of 30 years. This will age me somewhat. My first experience was none other than Lockerbie. And from Lockerbie, I've been involved in a number of sort of corporate manslaughter cases. Even got involved with James Bond, and currently involved in Bow Street and another big investigation that's taking place in relation to the Corniche, which is on the South Bank. I just really want to emphasise with this slide the difference, a planned response and a not planned response, and why, from a legal perspective, planned response are so important. Because as we all know, the first 24, 48 hours of any crisis is absolutely critical. So if you're in a position where you've got a well-trained, rehearsed team, they understand what's in front of them, they've anticipated the sort of issues which you should be able to do that are likely to arise, they're much better able to execute the plan, and therefore you have a much better opportunity of controlling the narrative and therefore a better outcome. And I want to, on this side of the fence, just sort of emphasise, Jonathan made reference to World Cup. I want to do something a little bit more current. Last night, Leicester played Nottingham Forest. Nottingham Forest recently invested considerable sums of money in 22 players. They could sort of get these people gelled together in a very quick time. Well, I think we saw last night when they got thrashed 4-0 by Leicester City, who aren't doing too well themselves. I can't say too much, I'm a Chelsea supporter. But you can see, it's sort of, what do you expect? If you bring 22 people together and you try and gel them into a team, it takes time. It's going to take more than 8 games. And so, clearly the situation here, imagine you've got this crisis on your hands. It's frightening. You don't really know what's happening. You've got people knocking at your door. You've got the police potentially. You've got the health and safety executive. You've got members of the press, and you don't even know who the right individuals are that should be responding. There's been no briefing on roles and responsibilities. You're not even sure who your lawyers are, because you'd notify your broker, and insurers would send somebody along from one of their panel firms who has no real understanding of what your business is actually all about. And so it takes time to develop sort of trust and confidence at a critical moment. And by the time you've got all of that bedded down, you probably lost complete control of the whole situation, and therefore your whole investigation is significantly prejudiced. You're chasing the 8 ball. So information is absolutely key. Getting that information quickly and accurately because without it, how on earth are you supposed to make any proper decisions? You want to understand, what am I actually dealing with here first and foremost? Is it a fatality, life-changing injury, or something a little less than that? And in the end, event of the fatality, the police are always going to be involved, and they will remain involved until they've determined whether or not there's any what we call culpable homicide. If there isn't, they will simply hand the investigation over to the health and safety executive, who will then look primarily at health and safety offences. But that in of itself can be quite alarming. You've also got media. So if we take Bow Street as an example, you had obviously a large number of journalists who wanted statements, interviews. Even the Lord Mayor of London was down there making all sorts of statements about how it was important for this investigation to be carried out speedily, so that they could understand exactly what happened, which is absolutely right. But you can imagine a small construction company ready to deal with that type of situation. Even a large company would find it incredibly taxing. And you think about, well, what sort of training? Has anybody in the organisation had proper media training? Because if we go right back to what Warren Buffett was saying, 20 years, 5 minutes, it only takes one misplaced comment to the media at a critical time when somebody's under considerable pressure for the company's reputation to start taking the proverbial nosedive. The other point I just want to make is around making sure you've got the right assistance in place from the outset. One of the very first calls I will ever make on a major investigation is to my technical experts. Who do I need to be supporting me from a technical perspective, who can, if you like, liaise with the regulator's own technical experts, scientific experts? And you don't want to be wasting time, because if you're dealing with a multi-party dispute, there will be other equally qualified organisations who will be making the same phone call. And so it's absolutely fundamental. I want the best people on our team. And if I wait too long, that won't happen. So within any plan, you want to identify what's the crisis situation that may eventuate. And secondly, who do I need? So I need this expert, this expert. You want to make sure you have their phone number. So the first call is to make sure you've got the strongest possible team on your side to deal with the incident. Somebody was talking about records. Records and the way that records are written will almost certainly determine the outcome of the investigation. You have to be so careful. Do not commit anything to writing until you are absolutely sure. And when you do, keep it factual. Don't speculate or give opinion. Meet with your colleagues, talk about the information, and only when you're certain, commit it to writing, because what will happen is that documents created will potentially subsequently become disclosable. And one of the ways that you need us, even though we may not be top of your Christmas card list, but one of the things you need us for is to protect your investigation from external scrutiny. And we can do that by invoking what we call legal professional privilege. So there's been a lot of debate in the courts as to whether documents created during the course of an investigation can be properly called privileged, because if they are privileged and the privilege is upheld, those documents do not become disclosable. So on almost every investigation that I'm involved in, one of the other than the experts, one of the first communications I will receive is from the client, not the insurance client, not the broker, but the client, to say we've had this dreadful event and we are very concerned that it may lead to prosecution and or civil litigation. And if the primary purpose for creating documents during the course of an investigation is litigation or prosecution, then you have a reasonable chance. It will depend on the evidence that you're able to provide at the material time, but you will have a reasonable chance of protecting those documents from external scrutiny. So it is so important that you think very carefully about before committing anything to writing. And what I often say is that sometimes within incident report forms, memos, whatever it might be, you find that conclusions are being drawn by people who aren't qualified. They simply think, well, this has happened, this is my view. But actually, the damage that they can be doing is incredible. I don't know whether you've seen in sort of accident reports, there's this one little horrid box. It's called, what do we do to prevent a reoccurrence? If you put a box in a form, somebody thinks, I've got to fill it. And they will do just that. And the damage could be irreparable. So be very, very careful. So these are the different types of enforcement action. It all begins with the notice of contravention, which basically sets out what it is that you as an organisation are said to have done wrong, what your material breach is, and what you need to do to put it right. What it does is trigger what we call this fee for intervention. The fee for intervention is an investigation cost. It's the HSE's investigation cost. So, which becomes payable 30 days after an invoice is actually received. And they currently charge the princely sum of £163 an hour. But they can be challenged. And they can be challenged on two bases. One, that you disagree with their finding of material breach. And secondly, that the amount they're actually claiming is excessive. So always think about that, because it's almost like by paying the fee for intervention, if there is a subsequent prosecution, it's almost predetermining what your position will be in relation to the prosecution. So if you do decide to pay, then make sure that you do so in a way that doesn't prejudice any future defence. Enforcement notices. These are improvement notices, so where a health and safety inspector comes onto a site, they see unsafe practice and basically say this is what you need to do to put it right, and you're given 21 days to actually put it right. And a prohibition notice where it's so dangerous, basically you just basically have to put a halt to the activity that's taking place. Now, what's really important about enforcement notices is they are a permanent stain on the character of a company. They're there forever. So if there are grounds for appeal, you should think carefully about appealing, because the impact commercially could be quite profound, particularly in public sector tenders, where you would be required to disclose the fact that you have been subject to an enforcement notice. And actually, prohibition notices have become slightly easier since the case of Chevron in 2018, where now you can introduce evidence after the event to challenge the inspector's decision that there was a dangerous activity taking place, which forced him to issue the notice in the first place. That wasn't the case. It was prior to 2018. It was whether the inspector had reasonable belief to issue the notice. Now you can introduce evidence after the event to challenge that decision. Then, of course, you have a prosecution, and then once you've been through all of that, there may still be an inquest to be managed. So the cost of getting it wrong, obviously financial, custodial, and reputational, as we've seen. And just some stats. The big stat is that over 90% of all prosecutions are successful. So you need to think about that very carefully before you embark. Why are they so successful? Because the operation of Section 40 of the Health and Safety at Work Act, which reverses the burden of proof. All the prosecution is bound to do in these cases is to establish that there was a risk from the activity that was actually being carried out. After that, it's up to the duty holder to demonstrate that they took all reasonable precautions to control that risk. Now that's quite a significant burden, and it's largely because of that that they are so successful. Now the Health and Safety at Work Act came about in 1974, and there's a lot of debate at the moment as to whether or not Section 40 should still be maintained, because in those days, some of you remember, if you were in breach of regulation, you were fined a maximum of £5,000. If you were in breach of a duty, you were fined £20,000. But of course, it's all unlimited now, and we quite often see very, very large fines. So there is a debate continues as to whether or not actually the prosecution should demonstrate that there was risk and breach. Now, as I say, we're still seeing significant fines, and there have been a trend towards more custodial sentences, which has obviously caused considerable alarm in the boardroom. Directors, in particular, wanted to know more about what their regulatory responsibilities actually are, and you definitely want to avoid this sort of situation, where you can see these are sort of well-known prosecutions with some very significant fines. This is one of my favourite, G4S. G4S, Harlow District Council, a Legionella investigation. So an employee of G4S contracted Legionella. The HSE believed it emanated from G4S's premises where he was working. They went in, did an investigation, but couldn't establish a causal link between the disease and the symptoms that he had contracted. However, they found that the systems they had in place for controlling an outbreak of Legionella was so poor that they were prosecuted for that. There was no harm, but the risk was significant, and the risk of harm was significant, and they were still fined £1.8 million. It's not about the harm that's caused, it's about the risk that's created. And that is why it is so important to make sure that you identify those risks and you manage them to the best of your ability.